De Garis and Neville Jeffers-Pidler Proprietary Limited was a 1990 case taking place in the federal court before Justice Beaumont. This case was a significant decision in the spectrum of copyright. It gave particularly insightful guidance on why fair dealing defences cannot be relied on when copying by intermediaries. The matter related to fair dealing, which is an aspect of Australian copyright law that allows materials to be copied without permission for certain purposes. The key provisions in our case come from the Copyright Act 1968, and they include research or study, criticism or review, and reporting of news. The applicants, De Garis and Moore, were both journalists whose work had been published in the Western Australian and the Sydney Morning Herald. The respondent was Neville Jeffers-Pidler, a media monitoring company. The nature of NJP's business model was scrutinising various newspapers and media outlets to provide a photocopy of relevant subject matter to subscribers in return for payment. The key issue in contention in this matter was that NJP had infringed copyright through the exercise of their business of being a press clipping service. De Garis and Moore argued that they were the author and owner of the literary work, and that NJP had infringed copyright by reproducing it. NJP denied that copyright had been infringed on the basis of fair dealing. In particular, NJP contended that the reproduction was for research or study, the reproduction was for criticism or review, or that the reproduction was for the purpose of reporting of news. Firstly, His Honour considered the issue of research and study. He considered its ordinary meaning in the Macquarie Dictionary as diligent and systematic inquiry into a subject to find facts or principles. His Honour determined that the information was not reproduced for research because it was for purely commercial gain. The intention was to photocopy the information for payment and not to conduct any particular research. Relevantly, His Honour highlighted that to make out a defence of research, it must be NJP's purpose to research and not incidental of his clients. His Honour applied a similar test to study to conclude that Section 40 was not available. With regards to criticism and review, His Honour determined that NJP put in no form of input into the final information. It was merely a photocopy, and thus would fail. Finally, with regards to news, His Honour noted that even though news does go beyond current affairs, as established in Commonwealth and John Fairfax, NJP simply reproduced the information, and overall failed to establish fair dealings as the information was merely reproduced for reward. The key ratio that the case established is that, pursuant to Section 40, the relevant purpose is that of NJP and not its customers. A Section 40 defence will only protect if the person doing the copying is using it. This creates a barrier for intermediaries or middlemen in relying on the defence. The outcome was ultimately that NJP could not reproduce the work.